Hello and welcome to the Goldwater Institute's annual Supreme Court Roundup. I'm Tim Sandefur. I'm the Vice President for Legal Affairs here at the Goldwater Institute. I'm joined by my colleague Jon Riches, who's the Vice President for Litigation. And incidentally, those are the only vices that we have.
A man with no vices also has very few virtues, as Abraham Lincoln said.
Wise thing. So we're here to talk about some of the Supreme Court's decisions this term, which some of the more interesting cases, I think, at least what I should say is the most interesting things about some of these cases, is the way that they set up what's going to come next year and the year after that. And for those of you who don't know, the Supreme Court goes out of session right before the July 4th holiday. And so they will tend to hold their most controversial cases for that term, for that week. And then they go out of session until the following October. So right now they're on summer break and they'll come back in the first Monday of October. So some of the decisions that came out this term, I think what's interesting about them is what they imply for future litigation.
Yep.
The first case we wanted to talk about that really does that is a case called FCC versus Consumer Research. And this is a case about the non-delegation doctrine. So the non-delegation doctrine is a rule that applies that limits Congress's ability to give power to executive branch agencies. And these are entities like the Environmental Protection Agency or things like that. And the Congress will often write a statute that, for example, says, there shall be no pollutants discharged into a waterway. Well, what is a pollutant? The Congress says, well, we'll let the EPA decide that. And so they give this authority to the executive branch to write up the rules that go in there. The problem with that, of course, is that the Congress might hand off the lawmaking power itself and basically just give away that power. Historically, for example, in ancient Rome, the Senate of Rome gave Julius Caesar the full power to make laws and then went home because there was nothing more for them to do. Or the legislature of France gave Napoleon the power to make the law and then walked away. And so we can't allow that in our constitutional democracy. And so we limit Congress's power to give away power to the executive branch. And one of the rules is the non-delegation doctrine. The non-delegation doctrine says that although Congress can give power to executive agencies, it can only do that if it limits it with so-called intelligible principles. In other words, Congress can allow them to fill in the details, but only as long as it limits what exactly these agencies can do. Well, you're allowed to define a pollutant, but you're not allowed to run wild and do whatever you want, for example. In the FCC versus Consumer Research case, the question was whether the FCC can impose revenue-raising demands. And the reason I put it that way is because there's some dispute over whether these are fees or taxes. Anybody who's done litigation in this area knows that there's always an argument over, is it a tax or is it a fee and all this sort of thing. Well, the FCC has this authority to run these programs of various kinds, and it can impose requirements that businesses pay into a fund to run these programs. So the question was, does that delegate the taxing power? And if so, are there different rules that govern those kinds of delegations as opposed to rulemaking delegations? So if Congress can allow the EPA to write rules, can it also allow the EPA to write taxes? It's very counterintuitive. Yeah. And the Court of Appeals said no. They said the non-delegation doctrine that we usually use in cases like this is not enough to protect us against unconstitutional taxes. And that taxes is really sensitive. I mean, the no taxation without representation and taxes imposed by the kings of England were always a central reason why we have the United States.
And what is the limiting principle?
Exactly. If they can tax $1, they can tax $100, which of course is why John Marshall famously said the power to tax is the power to destroy. So there has to be some limit. And unfortunately, what the Supreme Court said, the majority in this case, the majority of the justices said, it's not a different non-delegation test that applies. It's the same non-delegation test that applies to tax delegations and to rule delegations. So if Congress gives an agency the power to demand money from people, we decide whether that's constitutional using the same analysis that we apply in other kinds of cases. Now, the reason that that's important is really for what's on the horizon, and that's the tariff cases. The Trump administration has imposed these tariffs, these frankly unconstitutional tariffs, And the litigation over them is going on right now in the federal courts of appeals. We at the Goldwater Institute just filed a brief yesterday in the Federal Circuit Court of Appeals supporting one of these lawsuits against the constitutionality of these tariffs. And what that is the issue in these tariff cases is, has Congress given the White House the authority to impose these tariffs? And if so, what are the rules that limit that? Now, I don't think that the Consumers Research case, it certainly doesn't answer that question for the future litigation. It's just that if they had ruled the other way, it would have been a much easier day for challengers who are arguing that these taxes are unconstitutional. Things would have been a lot easier for them. So now it's going to be a little tougher for them to make this case. Technically speaking, what the Supreme Court said is Congress doesn't have to put a numerical limit when it gives revenue-raising power to an agency. Yep. So that's not a broad ruling. Nevertheless, if you read the opinion, there's some disturbingly broad dicta in there. And, you know, John, what surprises me about this case is that the liberal justices would write this opinion knowing these tariff cases are coming. And then take such a strong pro-executive branch position.
Yeah, that is interesting. I thought it was also interesting from the conservative side. It seemed to me that after Loper-Bright was decided and the Supreme Court dealt with deference and some of these other bigger issues in administrative law, non-delegation was going to be next up on the chopping block. Mm-hmm. But in this case and another one this term, it seems like there's not a huge appetite for it. Even though in previous terms, the same Supreme Courts wanted to kind of cabin agency authority under non-delegation. So that kind of surprised me as well.
And you know, non-delegation is one of these things that sounds kind of obscure and technical and nerdy, but this is a very important, huge deal because every agency, every executive bureaucracy, from the EPA to the FTC to the FCC, whatever agency you want to name, they're given this power by Congress, and Congress loves to give its power away. Right. It loves to do this. They love to. They claim otherwise, but they really love to give away their power because if they give away their power, they also give away their responbody.
Right.
And so then they can't be held responsible for things.
We vote for clean air. You figure out what that means.
You figure out the details.
Yeah.
So I agree. It would have been nice if they had put some teeth in it. One bright side, if you're trying to look for a silver lining in this opinion, is. And it's by Justice Kagan, very the leader of the left on the court, but she cites in a positive way the case of Schechter Poultry, which is a 1936 case, 1937, 36, I think, which is one of the last times the Supreme Court has ever actually enforced the non-delegation doctrine.
Wow.
And that was a case where the court struck down major New Deal legislation. And ever since then, people have been like, yeah, that was almost 100 years ago. You know, things are different now, et cetera, et cetera. And now here's Justice Kagan citing it in a positive way and saying, yes, the Schechter Poultry case was rightly decided. And if things get that bad, we'll say so. So I guess we'll see whether they say so.
It reminded me, too, you know, obviously this is the U.S. Supreme Court. It deals with federal non-delegation, but we do so much work with state constitutions and bring so many of our cases in state court. We had that Super Bowl case in Phoenix where the city of Phoenix essentially delegated to a private entity, the NFL committee, the ability to regulate signage in downtown. And we argued that
restricting speech, freedom of speech.
Yeah. And we argued that was an unconstitutional delegation to a private party, and the trial court agreed with us.
Yeah, I don't remember what the time period was, but it was during the days around the Super Bowl. An entire area of downtown Phoenix, all of the signs that businesses could put up had to be pre-approved by the NFL in order to promote the Super Bowl. Are we even allowed to say Super Bowl? I think we're supposed to say the big game nowadays in order to protect the profits of a private business.
Right.
Anyway.
Yep. So, you know, there's still hope in the state courts as well. So that's always something.
Yes, it is important to say that these doctrines like non-delegation also have purchase at the state level, and it's really important to see that they're enforced.
Absolutely. Well, let's talk about Trump v. CASA. This was probably one of the bigger decisions, or at least one of the more controversial decisions of the term. Initially, the cases that led to this were brought under Trump's executive orders, essentially banning birthright citizenship. So if a child was born to an illegal immigrant under the Trump EOs, that child was not entitled to United States citizenship. So that was the facts that brought him, but it kind of came up to the Supreme Court on a weird posture. Some lower courts had declared that unconstitutional and then had universally enjoined President Trump's EO. So the government, the federal government in that case, brought in an emergency application for relief. So the question that ultimately got up to the U.S. Supreme Court was not really on the merits of birthright citizenship, and maybe we can talk a little bit about that because that's going to be litigated in the lower courts now.
Yeah.
But the question that the justices were wrestling with were whether nationwide injunctions were permissible. So a nationwide injunction is an order from a court that doesn't just restrain the government from doing something with respect to the parties to the case, but universally restrains the government, even for people that might be unaffected by, or even for people that aren't parties that are affected by it. So this is a controversial issue, this issue of nationwide injunctions. And the court gave this sort of strange decision where they said that the 1789 Judiciary Act does not permit the federal courts to issue nationwide injunctions. If they're going to issue relief that restrains the government, it can only be with respect to the parties before the case. I think that's an important kind of first point. The court didn't say nationwide injunctions are always impermissible, and they didn't make the decision, or they didn't decide it under Article 3, which would have been that could have been very problematic.
There were some justices who wanted to do that, right?
Yep. But it was limited to the Judiciary Act. So I think that is sort of an interesting piece. And I guess it raises this question, is it still possible to get a nationwide injunction if that is the only way in which complete relief can be afforded to the parties before the court?
And there's this one simple answer that the court itself gives is, well, bring a class action lawsuit. If you bring a class action lawsuit, then of course the court is going to issue an injunction, if you win, that bars what the government's doing, from going forward in any case. And honestly, John, to me, this case seems like a bunch of fuss over really very little.
Yeah.
This is what doesn't compute in my brain about this case. Technically speaking, the question is, does a district court judge, the lowest level federal judge, does he have the authority to issue an order that bars the government from doing something even outside of his jurisdiction? Does a California federal judge have the power to ban the federal government from doing something in Maine? Well, technically speaking, the answer to that, of course he doesn't. He doesn't have jurisdiction.
Right.
But what difference does that make since something that's unconstitutional in California is also unconstitutional in Maine? So if the judge just limits his injunction to these plaintiffs and these defendants, and the federal government goes ahead and does that unconstitutional thing in Maine, well, okay, then I can run off to the court in Maine and get an injunction there. So what difference does it make ultimately? Really, it seems to me that the only people who argue that this is a real problem are people who want the federal government to get away with more unconstitutional things.
Right.
They're like, well, it's okay if you enjoin it in California, but we want to keep violating the Constitution in Maine. I don't see how that benefits anybody.
Yeah, it is bizarre. There's a whole bunch of reasons why I think it's a problem, right? I mean, if a law in all of its applications, or a regulation in all of its applications, is always unconstitutional, then really the remedy is to stop that from going into effect.
How could it be otherwise? I mean, when 3 or 4 years from now, when we have a Democratic president and a heavily Democratic Congress, and they decide to confiscate all of the guns in America,
right?
I mean, people are going to run down to their federal judge and they're going to say, give me an injunction to prohibit this. And are we all supposed to say, well, that injunction only works within a 3-block radius in Los Angeles, but you can go ahead and confiscate somebody's guns in San Francisco or New Orleans? I mean, it doesn't compute in my brain.
And will it lead to more litigation? So say an injunction issues with some specific parties in Arizona, but then different parties in Texas are being restrained by the same law, and they've got to file their own lawsuit. Will it lead to additional litigation?
It'll lead to more conflict between the courts, I would think. And don't we want to get this stuff resolved as quickly as possible? Again, I'm not saying that people are wrong who say that a federal district court judge lacks jurisdiction. Of course, that's absolutely true. But where the rubber meets the road, I don't see why this technical, you didn't dot your I and cross your teeth sort of stuff really helps anybody, except to let the government do more unconstitutional stuff.
What about the, I guess it's really not a federalism argument, but what about the argument that these decisions might be different regionally or within different districts?
Yeah, that's true, of course. But isn't that always true anyway? I mean, anyway, like I said, and as you said, it doesn't get to the merits of birthright citizenship yet.
Let's talk about that. Why don't you
Well, so
frame it out.
The issue in the birthright citizenship litigation is over the meaning of the 14th Amendment's first sentence, which says all persons born and naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. So the question is, what does "and subject to the jurisdiction thereof" mean? And when people hear "subject to the jurisdiction," they often think that just means you have to follow the law. But that's not what it means in the 14th Amendment. We know that for sure. Because everybody has to follow the law, and that doesn't mean that you're a citizen, right? Even a foreign tourist who's here for just one day still has to stop at the stoplights. Right. And that doesn't mean that his kids are automatically citizens of the United States. Jurisdiction in that phrase has to mean something broader, something like citizenship jurisdiction or allegiance, or at least this is the argument that the challengers are making, the administration is making. And the reason it's in there is because in 1868, when the amendment was written, Indians weren't citizens, and so their children weren't given birthright citizenship. No longer true, of course. In 1924, Congress made Indian citizens. But the real problem with all of these arguments about what were the authors of the 14th Amendment, what did they think jurisdiction means, is that immigration wasn't illegal in 1868. Right. There were no laws against it.
I think that would surprise a lot of people.
And because of that, we can't know what people would have thought about the question of, does the child of somebody who has entered the United States illegally, is that person subject to the jurisdiction in the sense of the 14th Amendment? I don't think we can actually answer that question on originalism grounds. There are some great writing out there on both sides. Evan Bernick on one side, John Eastman on the other side, other people who are going back and forth, Ilya Somin on the no side, or on the yes side. I mean, there's lots of great scholars out there. But the bottom line is we really can't know, because it wasn't illegal back then, and the issue just didn't come up. The question did come up, do the children of Chinese immigrants qualify in California? That was a big issue in the 1860s.
The answer is yes.
And the answer given in the Senate was yes. And yet that senator who gave that answer got thrown out of the Senate. The voters rejected him the next time around, right? So what does that tell you? Anyway, I think it's kind of up in the air.
Yeah, it is a close question. It is not close if you talk about, diplomats or invaders. Obviously, those children are not going to be citizens of the United States. But
why? And I think the reason why is because they're not subject to citizenship jurisdiction.
Right, exactly. Well, we'll see how that one plays out.
We will. It'll be a big year.
Let's talk a little bit more about administrative law. Do you want to discuss the White Lion case?
Yeah, so obviously this is an issue that's of great importance to the Institute, is the power of the administrative state and how agencies go about doing their job, since they really exercise almost all the governing power nowadays. And this case, called FDA versus Wages and White Lion Investments, is a case about the approval by the FDA of vaping supplies, vaping equipment. And the FDA set up this rule, kind of a process in broad terms about how they were going to either approve or deny the permission to sell vaping supplies. It was written in rather broad terms, and this was back in 2019. And when those were issued, the agency said, well, we're not going to require this, we're not going to require that, and that sort of stuff. And then they changed their minds over time. And then they started requiring, technical longitudinal studies and other kinds of scientific analyses that they didn't require before. And so then they ended up denying this company permission to sell their product. And so the company sued and said, well, you're changing the rules in the middle of the game. And that's what they call arbitrary and capricious. That's a behavior by the agency that's illegal. And the Supreme Court said, no, that's okay. And the reason they said it's okay is because the FDA's statutory authority is so broad that what they did falls within that authority, so it's okay. And honestly, this kind of surprised me. I was really sure that the court was going to go the other way in this case.
Yeah, that's what I was going to ask. It seems like another retrenchment from what we thought was going to be some good administrative law decisions, things that would cabin the power of administrative agencies.
In fact, here's a quote from the opinion. The court says, "It is hard to find in all the verbiage, that is the statute or all of the correspondence between the entity and the business, it's hard to find in all of this verbiage any specific commitments about exactly what sorts of scientific evidence an applicant would have to provide," end quote. And therefore the FDA was within its rights to deny. Well, the problem is that creates a huge incentive to write this stuff as broadly and vaguely as possible so that you can do whatever you want if you're the bureaucrat.
Yep. And obviously our solution here at the state level, at least part of it, is the Permit Freedom Act, right? So the legislation we developed said that if the government's going to have the authority to issue a permit or a license, it can't do it under vague criteria. It's got to be very clear about what the road, the rules of the road are, what the criteria are, and if it's not, then the permit requirement is invalid.
Right.
So, obviously this is a federal case, but I think that at the state level, at least, that's part of the solution to say administrative agencies, or even decision-making bodies like city council, you can't just sort of make up the rules on the fly. You got to say what they are at the outset, and they got to be clear.
And it occurs to me just now, if you combine this sort of incentive for broad language that the Supreme Court has created here, combine that with its avoidance of the non-delegation doctrine in the other case that we talked about, you have an even stronger incentive for Congress to give these agencies very broad power and let them, which is really surprising coming after Loper-Bright and these other Supreme Court cases that are consciously aiming at limiting the power of the administrative state.
Yeah, exactly.
A lawyer's work is never done, John.
No.
I'm just going to have to sue the government more.
That's all right. These make work decisions here. Another administrative law question that maybe this isn't a good omen for the proper movement of administrative law is the Bondi v. Vanderstock case. So in 2022, ATF, the Bureau of Alcohol, Tobacco, and Firearms, issued a rule that redefined the term firearm to include gun kits. So these are what are called ghost guns oftentimes. There'll be components of a gun that could be assembled into one, and those don't have serial numbers and things like that. So ATF, through its rulemaking power, said that if there was a frame or a receiver and other components that could readily be assembled into a firearm, that is a firearm for purposes of the statute. And interestingly, the statute carries criminal penalties. So the question went up to the Supreme Court as to whether ATF's redefinition of a firearm fell within the statutory definition in the Gun Control Act. And in a 6-3 decision, the Supreme Court upheld ATF's rule in a decision by Justice Gorsuch. And it didn't really turn out. So in a question like this, as our listeners are probably aware, if there's sometimes like a close call or if a statute is arguably ambiguous, that's where this deference problem has often come up that the court resolved in Loper-Bright, saying we don't defer to the administrative agency.
Right.
We just look at, we look at it anew and decide what it means. Here, what Justice Gorsuch said is that the definition of firearm under that applicable statute was clear. So we never even get to this question of balancing the agency's definition versus the regulated parties. And, he actually had a point. The way that the firearm was defined in the statute was any weapon which will or is designed to or may be readily converted to expel a projectile. And then it went on to say a frame or a receiver of such weapon as a firearm. So he said, look, the text is clear, and, ATF is within its authority to do this rule. What was a little bit interesting about this is there was a discussion about the rule of lenity.
Right.
And what that says is that in criminal cases, if there's an arguably ambiguous statute, then courts have to interpret it in favor of the criminal defendant, right? In presumption of liberty. And Gorsuch said, now, the rule of lenity, and he's probably the court's biggest proponent of the rule of lenity. And he said, no, it doesn't apply because the text is clear. But Justice Thomas wasn't so sure. He said, well, because there's criminal liability involved here, maybe the rule of lenity should lean in favor of a different definition.
And I always think that the most interesting cases from the Supreme Court right now are those where Gorsuch and Thomas disagree.
Yeah.
I always find those fascinating because they're both obviously very smart. They both write very persuasively. And I always find it interesting when they disagree about things to read each side of that issue.
Yeah, exactly. So, this did not, this I think was a pretty narrow decision. It involved just that specific statute. And according to Gorsuch, the legislative language was sufficiently clear. But I did want to talk about deference just for a minute because it's still around, right?
Yeah.
So last year, the Supreme Court decided Loper-Bright, and in that decision, the court said that if there's a vague statute, we don't defer to the agency. But of course, that only applied to the federal government under the Federal Administrative Procedures Act. It turns out about 36 states have their own APAs, and about that many state courts have said some version of state deference also applies in state procedures. So I think that's a real problem because obviously Loper-Bright was a huge decision. It dealt with the problem at the federal level, but honestly, how many Americans interact with the Clean Water Act every day? Many more Americans are going to have to deal with local agencies or state agencies. So the Goldwater Institute's solution to that problem is really twofold, but we developed legislation back in 2017, and Arizona was the first state to pass legislation that eliminated deference at the state level. And now a number of other states have followed suit.
In fact, Arizona is unique in that our law prohibits deference to the agency on legal questions and factual questions.
That's right.
And, when that got passed, there were those who said, "Oh, it's going to be chaos in Arizona. The government's going to fall apart. We can't regulate the polluters, and it's criminals everywhere, and dogs and cats living together, mass hysteria." And nothing like that has happened.
Right.
Everything in Arizona is still fine, except for the temperature is still 110 degrees. But other than that, it's a livable place.
Yep. But these are critically important issues. You can't have a regime where an administrative agency makes the rules, investigates the rules, adjudicates the rules before an ALJ, and then when it finally gets to a real court, the court says, "No, we're going to put our thumb on the scale for the agency." Yeah. You just can't have that regime. So
even if you're not a pro-freedom person, pro-individual rights person like we are, even if all you care about is democracy, this is a very
right.
big problem because we're talking about unelected officials who are making the rules that govern your life. So if you're concerned not primarily with liberty, but primarily with democracy, this issue still should worry you a great deal.
Yep. So hopefully the solution goes a long way and keeps working its way through the states and state legislatures. Let's talk a little bit about the TikTok decision because that got quite a bit of attention. So you might recall back in 2024, Congress and then President Biden passed a law that required TikTok's parent company, ByteDance, to divest TikTok's U.S. operations, to divest ownership, Chinese ownership over U.S. operations. Okay, so that's what the law said. You gotta sell the company. And TikTok and some content creators on that platform brought a suit saying that violated their First Amendment rights because TikTok is a means of expression, and Congress can't make this requirement. The Supreme Court, in a really tight timeline, they decided this case in a matter, I think, of 2 or 3 weeks.
Right.
The way it came up, upheld the law. And what was interesting about it is most of the discussion focused on standards of review. So the court was asking, should we apply strict scrutiny or should we apply intermediate scrutiny or lower form? Why don't you talk about why that's important, standards of review?
Well, standards of review for you non-lawyers out there, what happens is that the court, in deciding the constitutionality of something, it has to come up with a standard of review, which is its test, its method of deciding the constitutionality of the thing.
Yeah, and they decided under intermediate scrutiny, So cases that are decided under strict scrutiny, which of course is the highest form, federal courts about 75% of the time will strike down cases brought under strict scrutiny, which is really high.
Right.
So of course the parties here were really fighting for strict scrutiny. The court
they ended up in the middle.
And they ended up in the middle.
Because nobody really knows what intermediate
Right.
scrutiny means.
Right.
My friend Roger Pilon at the Cato Institute likes to say that they keep inventing new levels of scrutiny in the same way that the old astronomers used to try and come up with epicycles to explain the movement of the planets because they didn't want to admit that everything orbited the sun.
And that's a problem, right? I mean, you can't have this sort of like racking and stacking of the importance of individual rights.
Absolutely. Justice Thomas himself said so. There was a case some years ago where he and Justice Scalia said the picking and choosing of what rights deserve this kind of scrutiny obviously demonstrates policy making by the courts instead of neutral legal analysis.
And it is all judicially made up. I mean, the tiers are, and we have a case right now before the Arizona Supreme Court challenging Arizona's statewide mandate that private donors to private nonprofit groups got to disclose their identity to the government that's then publicly released. And
this issue's come up.
And this has come up, but it's under the Arizona Constitution.
Right.
And interestingly, of course, Arizona courts have not applied these tiers when we're looking at our own state free
in fact,
expression protection.
because this whole thing, not only was it made up, but it was made up in the 1930s. And so Arizona's Constitution dates to 1910 to 1912. So it really doesn't make any sense for Arizona judges interpreting the Arizona Constitution to use a federal legal theory that was invented after Arizona's Constitution was written to interpret the federal Constitution. It doesn't make a lot of sense. And yet the reason why state judges very often ignore that issue and just copy and paste what the feds say is because lawyers go to law school and they're taught federal cases primarily. And the reason they're taught federal cases is because if you're a law professor, you're not going to make a big name for yourself usually if you focus on state constitutional stuff. And you're not going to get a job at a law school in some other state. If you become an expert on the Arizona Constitution, you're not going to get a job at Harvard. You're not going to get a job at Yale if you do that. So the law professors all focus on the federal Constitution, and they teach their students the federal Constitution. And so you and I remember this. We graduated. We knew all sorts of stuff about federal law, but state law, you got to look it up. Yeah. And a lot of, these are busy judges and busy lawyers, and they don't have time to look it up, so they don't focus on state constitutional issues. And so you end up finding that federal stuff gets incorporated into the state legal decisions when they have no place being there.
No basis. Yeah, when I teach my class on public interest litigation at ASU, one of the first questions I ask the students is how many constitutions we have. Mm-hmm. And you'd be surprised a number of whom answer one. But of course,
which is not to say that state constitutions are all great. There are some pretty lousy. California's constitution it stinks.
Like many things that California does.
Totally. Alabama's constitution is infamous for being very, very long and complicated, and so there are problems there. But why make them worse by incorporating mistakes from federal courts just because it's easier to do that? Anyway, bit of a tangent there, but. The intermediate scrutiny is also complicated by the fact that nobody knows really what it means or how it applies.
Yep. And there were some dissenting justices that pointed that out. But what the court said at the end of the day is, look, there's a serious national security concern here. The Chinese government is able to manipulate this data. The way they phrased it was covert manipulation, and it's sufficiently tailored to survive.
In fact, I wrote down a quote from the opinion here. It says, TikTok's scale and susceptibility to foreign adversary control, together with the vast swaths of data that the platform collects, justify differential treatment to address the government's national security concerns.
Yep.
And then what happened? Nothing happened. TikTok is still operating like it was operating. It was an emergency, and then all of a sudden it's not an emergency, and we keep not doing anything, and it continues to operate, and it's like, well,
the law, in the text of the law, it granted the president a one-time waiver for 90 days if there was significant progress made toward divesting ownership, essentially. Well, that waiver was granted. That period has expired, and we're now on the third waiver, which is set to expire in September. So, the question is whether there's authority to exceed that statutory language and grant additional waivers.
To exceed the statute again to do an illegal thing again.
And whether that's susceptible to challenge, and if it is susceptible to challenge, who might have standing to bring such a case. So I think more to come on this one. Let's shift gears a little bit to the court's decision in Skirmetti.
The case everybody's talking about.
Yeah, this one did get a lot of attention, and this also raised tiers of scrutiny issues. But so what happened in this case is in March of 2023, the state of Tennessee passed a state statute that banned puberty blockers and hormone therapy for transgender teens. But the statute also allowed those same treatments for other medical conditions, okay? So plaintiffs who involve transgender minors and their parents and I think a doctor sued, and they argued that violated the Equal Protection Clause because it discriminated based on sex and based on transgender status. The lower court, the district court, applied heightened scrutiny because he found that it did discriminate on the basis of a protected class and blocked the law. The Sixth Circuit then reversed. It goes up to the Supreme Court. So really, once again, just like the TikTok decision, really the whole fight was about, is this a protected class and should heightened review apply or not? Or should just rational basis review apply? And in a 6-3 decision, Justice Roberts, writing for the majority, said that the proper standard of review was rational basis and upheld the law. So, we've talked about some of the issues with rational basis, but ultimately the decision was grounded in this notion that the statute was based on age and medical purpose. Those are not sex or transgender status, so they don't trigger heightened scrutiny. And then the court also said that transgender status is not a suspect class, and the court has never said that it is, and certainly didn't say that in this case. The dissent was interesting, I thought. Sotomayor and Kagan and Jackson joined her, observed that, quote, the level of constitutional scrutiny courts apply in reviewing state action is enormously consequential.
Yep,
well,
exactly.
I am glad she recognized that. I'm not quite sure if this was an economic freedom case or a property rights case, if she would have made the same observation. But, she made it here, and because it was age and medical purpose based, the law was upheld.
And, the sex discrimination argument, it's kind of interesting. Philosophically, it really is a very interesting argument because it's trying to build on the Bostock case from, what was that, 5 or 10 years ago now, where the question was discrimination on transgender issues and whether that violated the Constitution's prohibition on sex-based discrimination. And the rationale in that case was, well, you treat men differently than women and women differently than men, even though you're kind of treating them the same way in some sense. And this traces back to Loving versus Virginia, with the old case about interracial marriage. The government in that case defended the anti-interracial marriage statute. This is back in, 67, or I think it was. The government in that case defended the statute by saying, well, it treats everybody the same because whites can only marry whites and blacks can only marry blacks, which is kind of crazy, right? And the court said, well, that's crazy. That's not equal treatment. And so the question in this transgender cases often comes back to this same sort of argument. Is that treating people equally to say men have to be treated like men and women have to be treated like men and like women, and you can't treat people, they are not allowed to cross from one category to another in the law. And so in this case, in the Skermeti case, the question is, well, a boy can take a puberty blocker or testosterone for some medical conditions, but can't take them for other medical conditions. That is, he can't take, or he can't take female hormones, rather, in order to treat that condition. So he's allowed to take some treatments and not other treatments because those treatments are, the hormone for that sex versus that sex.
Right.
And therefore, I'm making a mush of explaining this, but the point is that you're not allowed to cross over those lines. Mm-hmm. And the court says, well, it's a clever argument to say that it's sex discrimination for the state to allow a boy to take testosterone for some conditions, but not to take estrogen for other conditions. They say that's too clever an argument, we don't buy it.
Yeah.
But you can kind of see the argument, and if you listen to the oral argument, I thought the lawyer for the challengers in this case did a very good job of making this argument. It's a tough forum and a tough argument to make logically, but he did a very good job of it. And it was just interesting. The court kind of backs away from that and says, we're not even going to get into the complexities of this philosophical stuff. This is a medical treatment that's being regulated. Therefore, it's a business, rational basis.
Yeah, exactly. Well, Tim, do you want to chat about the FDA v. Reynolds vape case?
Yeah, this is another case about procedure. One of the things that the court did a lot of this term is cases about procedural issues, who's allowed to sue and how people are allowed to sue. And so this case, as well as another case that we haven't mentioned called Diamond Energy, both of these cases are about who is allowed to file certain kinds of lawsuits. And in the R.J. Reynolds case, the question is, who is within the so-called zone of interest of a statute that allows them to sue? So if in this case, it was another case about vaping, by the way. It's another case about approval, the government's approval of a vaping product for sale. And the government denied the approval for this product. And so the retailers who intended to sell the product, they filed the lawsuit, not the manufacturers. And so the question is, under the statute, are the retailers allowed to sue or only the manufacturers? And that's similar to in the Diamond Energy case. What happened there was, it was a question about the approval of certain kinds of gasoline, certain kinds of fuels for automobiles to use. And in that case, the government doesn't. I think it was they prohibited the additive or something like that. But what matters is it had these effects. The government's action had effects on car sales, and so the car salesman sued instead of the manufacturer of the car or the manufacturer of the fuel. And so both of these cases are about, can these sort of downstream parties bring a lawsuit under the statute? And that then turns on the question of standing. Now, it's a little different than constitutional standing, because we're talking about statutory standing, but it's still important because it determines who can sue. And here what's unusual is in both of these cases, the court took a rather broad view.
Of standing.
It took an expansive interpretation. It says, well, yes, the retailers can also sue because they are the natural, they're going to feel the natural consequences of the government's action.
Yep.
And so it's like, you can imagine like throwing a rock into a pond. You know, it has these ripple effects. People even over here who feel the ripple effects, they're still allowed to sue over throwing the rock in the pond. Basically.
Right.
And that's really surprising because we're talking about a conservative court now. It's a 6-3 conservative court. And conservative judges tend to take a very narrow view of standing. They don't like to see a lot of lawsuits. They don't want expansive power for anybody to run off to court. I mean, we were just talking about the universal injunctions case, right? Yeah. They want limited judicial power. So it's kind of surprising that in both this case, the Reynolds case and the Diamond Energy case, the court takes this broader view and says even these people downstream qualify as within the zone of interests.
Yep.
Or in the Diamond Energy case, the term was whether they are regulated parties, right? Who is regulated? When the government comes in and regulates something, who is being regulated? If the government regulates this coffee cup, is it just regulating the person who makes the cup? Or is it also regulating a restaurant that might want to use this cup to serve a customer?
The person who drinks from it.
Or the customer who drinks from it, that's right. And so it's what's interesting to me about the Reynolds case is that they took this rather broad view.
Yeah, that is kind of, you wouldn't expect that.
And especially because the Reynolds case is written by Justice Barrett. And Barrett has been very much a stickler recently for who's allowed to sue and why. Yeah. She's taken a rather strict view. But in these cases, she arguably takes a broader view, at least than you might expect her to do.
Yep.
And, you know, credit to Justice Barrett, because she's been taking a lot of flack from some of our conservative friends lately who have kind of made it their mission recently to attack her and say that she's, you know, turning into a Justice Souter who's appointed by a Republican and turns out to be a Democrat. And that's really nonsense. It's really a silly position to take. So I think she's really shown, in just these past couple of weeks, she's shown why there's no ground for that kind of an argument.
And it does make a lot of sense, too. And just a reminder for our viewers, too, we have time for questions, so please send your questions in and we'll answer them. You know, this sort of got me thinking, the state of Oregon banned, through administrative action, of course, you know, not legislative action, gas-powered vehicles by some date in the future, 2030 or something like that.
Yeah.
And so then the question is, all right, well, that's probably unlawful in terms of an exercise of administrative power, but who has standing to sue?
Right.
Because, you know, it's not going to be the car manufacturers. They're not going to get in a fight with the state government over that. Well, this would seem to suggest, obviously I realize this was a statutory interpretation case, but this would suggest that the dealers would certainly have standing. But it seems to me it's the citizens of Oregon who are really most harmed by that. If you want to buy a gas-powered car, you should have the right to buy a gas-powered car. And if the government's telling you you can't, you know, should you
But on the other hand, of course, you always get into a sort of a little old lady who swallowed the fly problem, because eventually, do hitchhikers have the right to sue because the car is meant to take, you know, and that sort of thing.
That's right.
But, you know, I wanted to go back. One thing that we forgot to mention about the Skermeti case about the transgender youth issue, is that the court is taking a lot more interest in parental rights.
That's right.
And this is an issue that is of great importance to the Institute. We're doing a lot of cases now. We've done a lot of cases in the past on the issue of parental rights. The Supreme Court has said that parents have a fundamental constitutional right to direct the upbringing of their children and to make decisions regarding how they're raised and what the education that they get and that sort of thing. And unfortunately, the court, although it said that, it hasn't often put a lot of teeth into that. And I think both in this case and also, I can't remember the name of the case off the top of my head, but the case about children being allowed to be excused from the reading portion of the class day when they're being read textbooks. In these cases, I think the court is becoming more and more conscious of the way that public schools are infringing on parents' rights to raise their children. Now, and this is an issue that now, in the past 5 years, or however long it's been since the pandemic, I think it was really the pandemic that really set people to being worried about this issue, because they saw what was going on in schools, and they're worried about the fact that, you're right now litigating cases about schools trying to conceal information about from parents about what goes on in the classroom. And so it's a good sign if the court is getting more interested in protecting parents from the infringements on their freedom by public schools.
Yeah, no, that's a great point. We had a couple questions. The first, when we were talking about nationwide injunctions, they asked, isn't it a problem when you have one district court judge who's making policy from the bench as opposed to maybe applying the law? So this gets into the age-old debate over judicial activism versus judicial engagement, and where's that line drawn? And in my view, the line is drawn if a judge is making policy that's not rooted in the law, that's judicial activism.
Right.
A lot of other people say if I disagree with the judge, that's judicial activism.
Yeah.
Whereas judicial engagement is the courts doing their proper constitutional role and saying what the law is and enforcing constitutional boundaries on the popularly elected
That's right.
branches.
And this is why, like I said, it doesn't seem to compute in my brain, this thing about the nationwide injunctions thing, is because if just listen to the way the question is phrased is, well, isn't it a problem if a judge is making policy from the bench for the entire nation? Well, those are two different things.
Yeah.
The problem is the judge making policy, not the fact that he's doing it for the entire nation. If a judge makes policy even in one city, that's a problem, right? So I'm concerned about judges getting things wrong, not about them getting things wrong here versus there. And so this stuff about nationwide injunctions, I think, is kind of a misfire. What we should be concerned about is judges either being active or passive, but not following the Constitution. Well, people use the phrase judicial activism, and I'm much more worried about a passive judiciary than I am about an active judiciary. I don't want judges to get things wrong, but I really don't want them to just walk away and say, well, we're not going to do our jobs.
Particularly where the government is a party, right? They can't just say we're going to rubber stamp, the whole purpose of judicial review.
This year was the 20th anniversary of the infamous Kelo versus New London eminent domain case. And you talk about a perfect example of a non-activist judiciary, right?
Yeah.
That's what happened, is the government stole Suzette Kelo's home in order to give it away to a private company to build luxury condominiums. And the U.S. Supreme Court said, whatever. That's not being a judicial activist. So if you want a passive judiciary, that's what that is. And I don't think that's a win.
No, that's judicial abdication. I think that's probably a much better way to describe it. This is an interesting question. Is there a general direction on how the court is addressing the use of presidential power or executive power given the makeup of the court? What do you think about that?
Well,
I think it's TBD in a lot of these.
It is, and it's a little early to say.
Yeah.
And also, this is another thing that's been coming up a lot in the law professor, law geek world, is the use of what they call the shadow docket, the court making decisions not on cases that have been fully briefed and argued, but in some sort of preliminary stage, where it's an injunction, a temporary injunction, or a motion, and then it goes up to the U.S. Supreme Court, and the court decides it in a much faster process than it usually does.
Right.
And so there's been a lot of talk about maybe that's where this kind of bias is showing up, that the court's being more skeptical or less skeptical than it should be at that level. As you said, I think it's hard to really say. there's no doubt that obviously conservative judges are going to tend to be conservative in their decisions, and they're going to see things from a certain perspective, and a conservative administration is going to tend to be parallel with that. But this administration is not a conservative administration, right? This is an unusual situation where you have a Republican president who does not do what Republicans tend to believe in, right? Free markets, limited government, and so forth. And so it's not necessarily the case that the conservative justices who were appointed by Bush or somebody like that they're necessarily going to fall in line with the Trump administration. And of course, the liberals, they might agree with the Trump administration on some things and disagree with them on other things. So it's really, it always bugs me when people are like, oh, it's a Republican judge who, and law is just politics and all this. It's much more complicated than that.
There was another question about criticism among the justices and whether that's been getting more severe. And it's Justice Barrett's criticism of her colleagues. Do you think we're seeing more of this?
Did you see this where Justice Barrett, in one of her opinions, just starts out with, "We will not bother to respond to Justice Jackson's hyperbole," or some term like that.
Yeah, it's contrary to 200 years of precedent and the Constitution itself. Yeah,
that was pretty stringent.
Yeah.
Sometimes they always say, "I respectfully dissent." Sometimes
Right.
you can see them kind of clenching their teeth when they say the word respectfully.
Right. Yeah, I think it is. We are seeing a little bit more, but there's always been, I think, strong dissent. And Scalia was the master of strong dissents.
That's
so
right.
I'm
And
not sure.
the history of the Supreme Court, there have been justices who just hated each other. Was it? Trying to remember which ones. I think it was Frankfurter, who hated Douglas or something like that. So there's always been personality conflicts on the court, one way or the other. They rarely show up in the opinions, but there have been times. There was a famous incident during the bombing of Cambodia during the Nixon administration when Justice Douglas issued an injunction forbidding the bombing of Cambodia. And Justice, I think it was Justice Thurgood Marshall, issued an order in response to that, vacating that order and saying no further orders shall be issued without the full Supreme Court hearing, which was kind of a nudge among two very liberal justices,
Right.
So they don't always agree. In fact, Justice Sotomayor just this morning, I believe it was, issued a statement distancing herself from Justice Jackson in one of these shadow docket cases where Justice Jackson wrote this long dissenting opinion objecting to the court's decision, and Justice Sotomayor issued her own one paragraph where she says, well, I sympathize with where Justice Jackson's coming from, but that has nothing to do with this case, or something like that.
Right.
Really kind of shocking if you think about it.
Yeah. Yeah,
But I don't like this piling on Justice Jackson. I think Justice Jackson she takes a lot of heat from the right, obviously.
Right.
But she is a very fine justice. She writes very well. She's on top of, and a lot of the issues she's very good on. So we shouldn't join in this partisan cheerleading.
So you started the discussion with the observation that you thought that a lot of cases from this term were setting up for some bigger cases, maybe next term or the term after. Where do you see those headed?
Well, the big one, I think, is definitely the birthright citizenship thing.
Yeah.
That's obviously coming up. And I think tariffs, that's destined for the Supreme Court one way or the other. So those are the two big ones. I think the issue that's on the horizon is parental rights. I don't know if it's going to be this term or, hopefully, fingers crossed, like we've got a couple cert petitions. We were kind of disappointed they rejected one of our cert petitions in another case recently, which was disappointing. But you keep knocking on that door and eventually they'll open it. But those are the big, what do you think are the big issues coming on?
Parental rights for sure. It's been so long since the court has issued a strong parental rights decision vindicating
It's been 25 years, I think.
Yeah, and before that it was,
Almost
25
100.
years. Yeah. So I think that's coming up. I think administrative law will still be a biggie. I was disappointed to see some of the non-delegation stuff, but I think reigning administrative power is going to, because with guys like Kavanaugh and Gorsuch, that's what they're interested in, and those are the issues du jour. So I think we're gonna have to start to see some of these the authority of agency rulemaking and the extent
and it would
to which
be nice
exceeds.
if there's a couple things that it would be nice to see if they would revisit. One of them, of course, I mentioned Kelo.
Yep.
It would be nice if they would revisit eminent domain. It's been 20 years. It's an almost entirely new court at this point. Everybody knows Kelo was wrongly decided. The time has really come for them to take up this issue. A lot of states have already started to say that, have over the years have said they have a problem with Kelo. So it would be nice to see them take that issue also. And then, of course, were the union issues. You know, the follow-ups on Janus. After the big Janus decision that protected the rights of employees not to be forced to support or join a public sector union, the court then stepped back and it's almost as if after Justice Scalia died, they lost interest. I sure hope that's not the case.
I think with Alito there, he's sort of the main guy that understands how pernicious government labor unions actually are and how it really disrupts the normal lawmaking process where you have these private parties with such enormous influence over public policy that they really shouldn't have, and then using their political authority to impose those policies on all Americans.
Right.
And Alito, I think, gets that, but you're exactly right. I think they got to, at some point, take up some of these follow-on cases. I just saw a new case where, unions will just, even if somebody asks to be out of the union and say, I don't want to, give you my money anymore, they're like, well, you can't do that unless you do it in 1 week in March a year from now.
Right.
So I think there's going to be a lot of stuff.
Yeah, the unions are very good at finding a way to get around the existing precedent and still deprive people of their rights. And then so you have to sue every time and hope the court will take the case. And if I remember right, it was less than 60, I think, cases from the U.S. Supreme Court this term.
That's right, yeah.
So they're asked to take about 10,000, I think it is, per year, and they used to issue about 80, and now they're down to 60. They're slowly putting themselves out of business and leaving these issues at the circuit level a lot of the time, for decades sometimes, even when they disagree. And that's not a healthy way for the courts to operate, I don't think.
Yeah, enormously difficult to get cert granted, as we're learning.
Which is all the more reason why people should focus on state constitutions, go to state court, raise these issues at the state level, the way that we do at the Goldwater Institute.
That's exactly right. And I see we're right at about the time. So we want to thank everybody for joining us today. Feel free to follow our work at goldwaterinstitute.org. And if, of course, the government violates your rights, feel free to reach out to Tim and me so we can sue them on your behalf. Thank you very, very much for joining us.